If you're building with AI right now, there is one question you need to start asking before you launch your next feature. Not, can we build this? The real question is, what happens if this AI system causes harm? Because founders, vibe coders, startups, and employers are moving fast right now. They're integrating AI into products, workflows, hiring tools, health tools, financial tools, customer service tools, productivity tools, and decision making systems. And a lot of them are assuming that if the AI makes the mistake, the company gets to blame the AI. That is not how liability works. Quick note before we get into it. My name is Lisette Eusebio. I'm an attorney and tech founder, and this is my digital twin. I use it so I can move faster while I'm building, but the legal issues we're talking about here are very real and I want to cover them. So let's get into it. The first mistake founders make is thinking about AI like it is just software. Traditional software usually follows predictable instructions. A user clicks a button, the system performs a task. The output is usually easier to explain. Well, we are not living in that world anymore. AI systems are different. AI can generate content, it can rank people, summarize information, and recommend decisions. AI can classify users, AI can flag risk, AI can make predictions and ultimately influence what a person does next. And the more your system influences real world outcomes, the more legal exposure you may be creating. That is where a lot of startups are going to get surprised, because when you build an AI product, the legal system is not only going to look at the model, it is going to look at the entire chain. If it exists, we will find it in litigation. We will want to know, where did the data come from? What did the system do with it? Who relied on the output? Was there a human review? Was the user warned? Was the person affected given notice? Could the decision be challenged? Could the company explain how the output was produced? Those questions matter. And if the answer is, we don't know, the AI just did it, that is not a strategy. That is a liability problem. One example is AI in hiring and employment. If a company uses AI to screen candidates, rank applicants, match people to jobs, or score workers, that system may affect someone's opportunity to get hired, promoted, or considered for employment. That means the AI output is not just a fun technical feature. It can cause harm and have real adverse effects on individuals. It may become part of an employment decision. And once your product starts influencing employment decisions, you are entering a much more serious legal environment. This is why cases like Kistler versus Eightfold AI matter. In that case, the plaintiffs allege that Eightfold's AI system collected and analyzed data about people and generated employment-related rankings or scores in a way that should trigger obligations under existing law. Eightfold disputes those allegations, and the court still has to decide what applies. I covered that case in a different video. Now let's talk about another risk area: data. Every AI system depends on data. Training and user data, scraped data, uploaded data, third-party and internal company data. Well, the data was public. That does not automatically solve the problem. Public does not always mean free to use for any purpose. A website can be public and still have terms of service. A data set can be accessible and still be restricted. User information can be visible and still raise privacy concerns. Content can be online and still be protected by copyright. So if your startup is scraping data, feeding it into AI, using it to train a model, or monetizing outputs based on that data, you need to understand what rights and liability you actually have.